Assalamualaikum. Welcome to the Beta program, and I am your host Tariq Khan. We as Indian legal system is a combination of invalid, illegal laws such as draconian laws, which are violating Indian Constitution. As you know, in the previous episode, we have also analyzed and explored how India has violated Geneva Convention. So today we'll discuss and analyze how India is using invalid, illegal laws to violate Indian Constitution. So, Advocate Rehana Ali has joined us from UK. You are Information Secretary of Tariq Kashmir UK. You are also analyst and expert on Kashmir issue, and you are also program host of the Live with Rehana Ali. Assalamu alaikum, Advocate Rehana Ali, and thank you so much for joining the Beta program.
Walaikum salam, and thank you for offering me the opportunity again to actually become a guest in your show.
Madam, since the partition of subcontinent into India and Pakistan as an independent state in 1947, India has always used to promote itself as a democratic, liberal, and peaceful state. But the case is that the international community observed that India has violated its own constitution by implementing lockdown and violation of massive human rights, not only in Indian occupied Kashmir, but within the India itself, while breaking minority rights and imposing Hindutva extremist ideologies. Despite of these, considering these entire developments, do you think that India has still right to call itself or promote itself as a democratic, liberal, and peaceful state? How would you analyze this?
Okay, first of all, I would like to actually give very a simple definition of what does mean by democracy. Democracy is that where people get a right, the right to say what they like freedom of expression, which is Article 19. So, what is freedom of expression? That you can read, you can broadcast what you think is right, and you can write articles, you can write on social media, and you can publicly publish anything which you feel is actually right and is for the betterment of the country. Now, India calling itself a democracy. India can't be a democracy, and the biggest reason is that India is a country which is based on caste and class system. A country which has caste system and class system, it cannot be a democracy. And apart from that, India has draconian laws which are below the international anti-terrorism standards and the other standards of laws. So how can India actually become call itself a democracy? Now, India calls itself the world's largest democracy, and to become the world's largest democracy, India doesn't have all the elements there. Like, for example, how can India become a democracy when it's actually made of caste and class system? So these things actually don't allow India to actually be a democracy. And then India's own like draconian laws, which are domestic laws, and these domestic laws are violating Indian constitution, so it cannot be a democracy. And then the third thing, I would actually like to add on, that India is also violating its actually own articles in actually different ways, I will speak about that later on. So India can't be a democracy. And then I move on to number two, which was asked about secular, the second part. Now, what does it mean by secular? Secular means it doesn't matter if somebody believes in God or not. So that's a personal matter. But what is happening in India at the moment, not at the moment, it's been going on from a long time, but at the moment it's actually much more highlighted that India is not understanding that what it means by secular. India is into the question, are you Muslim, are you Hindu, are you Sikh, are you Christian? And then it's actually violating the word secular because it's not understanding the word, and then it's actually more into what people believe in. So that means that India is not a secular state. And then the other reason why it cannot be secular is that Indians' own article, Article 25, which is freedom of religion. So whichever religion you actually are from, you can promote it, you can live according to your upbringing, to your beliefs, and to your like promotion, you can actually promote your own religion as well. But what we see is that it's not happening at the moment. We see a lot of Muslims and Sikhs, and we see other Christians have been like prosecuted, and this is not happening every other day. It's nearly daily. And the biggest contradiction India has in its own art. And the biggest like India has in its own article is the biggest issue which India has at the moment, like calling itself actually a secular state, is that Article 25 says that it's freedom of religion, and then Article 25A is a contradiction where it says that Sikhs have to live like Hindus, like Sikhs have to marry with the Indian Marriage Act, and if they want to adopt somebody, it has to be under the Indian Adoption Act. And then if they want to pass on anything to the children, like inheritance laws, they have to be under the Hindu like act as well. So this is a like it's actually unbelievable that that under this article is saying that you can promote your religion or you can believe in any of the religions you like. They're all equal. And then in 25 subsection A, this is what it's actually saying, and this is actually a big contradiction of its own article. And Sikh's religion is a religion. It's a very peaceful religion and is being accepted by the world. But India, calling itself the largest, that there is Sikhism is like a religion. And now the third part, peaceful. Now, how can India be peaceful when there's so many things happening? And how can we say that India is promoting peace? It's not promoting peace, it's promoting terrorism. Because at the moment, we actually see how the different minorities are being treated. And not only that, even if you look at Indian neighbors, like India has always had problems with Pakistan. It had 3 wars with, actually about 4 wars with Pakistan. And it had a war with China too in 1962. And India has issues with like Nepal ongoing as well. With Sri Lanka in the 1980s, they had problems. And then, all states next to India, none of them are actually happy with India. So we can't say that India is promoting peace, especially with Pakistan. Like it has been confirmed with Kulbhushan Yadav that he entered Pakistan through actually Balochistan, which is a province of Pakistan, where he was acting, where he was an Indian raw spy, and he was there for committing terrorism. And he actually, like many 100,000 people died because of his involvement in terrorism. And there are many other accountable like incidents happening in Pakistan, in Sindh, and then in KBK, and that we hear like every few months or weeks there is something happening. So it's all Indians' involvement. So how can we say that like India is a peaceful state? And I would like to add on as well. In 1980s, India was the first state of the world which introduced suicide bombing. So suicide bombing didn't take place because which were trained by India.
How would you analyze why India has always violated Indian constitution through implementing illegal and invalid laws, including draconian laws, detention laws, and they're imposing on Kashmiri Sikhs, Christians, and what are the articles contrary to each other oppressing these minorities? How would you analyze?
I would say that the draconian laws are not part of Indian system, because if you look at the Indian article, Indian constitution and the articles, they are a contradiction, because in the articles it's actually speaking about equality. So like under article 14, like everybody is equal in the eyes of the law, and they have equal representation. And then article 15 talks about that it doesn't matter whichever sex, religion, race you are going to be treated equal in the state of India and under the law. And then if you look at Article 17, which is about untouchability, that like anybody who is involved in untouchability will be actually prosecuted. And I would like to add on one thing here, that most of the laws which were made in India and which were abolished and which were amended, they were to do with untouchability. Like they were about the Shudras, Adivasis, people who are from lower caste, which India actually calls. So they were made for protection for them, and it was made for protection for different minorities, because different minorities are actually in the same category as the untouchability. Because if we all recall in the days when subcontinent used to be one country called Hindustan, at that time, if any Muslim touched any Hindu or went near any Hindu place, they had to go and make it like clean it, like with the holy water. So this actually confirms that Muslims were treated in the same category of the lower caste Hindus, like they were treated they come under untouchability. And the funniest thing is that, like, after all these laws been made and then been amended, and then they've been abolished and new laws taking place, the matter is still there. So this is something that India needs to actually think about. If it thinks that it's a democracy, it can't be a democracy on this basis as well. And then I'm going to move on to Article 19. So what is Article 19? Article 19, as I said earlier, it talks about freedom of expression and freedom of speech on and offline. Like it can be through electronic media, it can be in person, it can be broadcast, and it can be writing articles and going on social media. So what India is doing at the moment, that India is arresting any single person, regardless of whatever faith they believe in. Anybody who talks about the atrocities, anybody who talks about the unfairness, anybody who talks that India is a democracy is being arrested. And first of all, they're detained, and some are being arrested as well. So India's laws, which are to do with detention, are actually violating this article. And then I would like to move on to Article 20. Now, what is Article 20? Article 20 means is that if one person has been punished under a law, you can't punish them, like you can't reject that punishment, like change your mind that I'm not going to give this punishment, I'm going to give this punishment. You can't. So once a punishment has been established, and for some reason it's the wrong punishment, that person cannot be punished again. So this is Article 20. And we see that India is always India has different laws. Like what I know is that if somebody is being arrested with some money law in Kashmir, and then they actually, like during their time being arrested, they can quickly change the punishment into Public Safety Act. Like they can easily actually put that on. And there are some other detention laws as well which have been slapped onto victims. So all of these things which are happening in Kashmir and in India, like this seems like a violation of actually Article 20. And then I would like to move on to Article 21. Now, what is Article 21? It says guarantee to life, protection to life and personal liberty. Now, what does that mean? That anybody who's under the state of India, their life has been protected and they have personal liberty. But what we see is in the past years that what Indian Army has been doing in Kashmir is that they have been tying civilians onto the jeeps and moving them in the valley. So in case anybody attacks the Indian army, the first person they are going to be attacking or they are going to be killing is not going to be Indian army, it's going to be the Kashmiri. Now, where does this comes under war crimes as well and crimes against humanity? And this is a clear violation of Article 21, which is guaranteed to life and personal liberty. And India has been doing this for a long time. And India is using rape as a weapon of war, and at the same time is using civilians as actually like human shield, which is actually a violation of Geneva Convention as well. Because like Kashmir is a disputed state, and the people in Kashmir are protected persons, which comes under the Geneva Convention, which India has signed treaties and Geneva Convention that is going to be respecting human rights. Now I'm going to move on to actually Article 22. All these articles I'm speaking, they're actually related to Kashmir and Muslims and other minorities as well, but mostly it's about Kashmir that like I'm actually trying to highlight at the moment. So Article 22, what is Article 22? Article 22 means that anybody who will be arrested or detained will be informed for the reasons they have been arrested and detained. They will be given a right that they can defend themselves, or if they like, they can um, have a lawyer of their own choice. But what's happening in India at the moment is these draconian laws which India has actually made. They are contradiction to it because they don't allow, like Public Safety Act, Unlawful Activity Provision Act. These laws don't allow the victim to know that why they have been detained. And only the family members can approach and ask for justice and ask the reasons, but themselves who have been detained have no clue, and they've been taken away for months. Like normally it's actually for 4 weeks. They have an advisory group which actually sits down, and they talk about what can be done, or if this person needs to be detained and for how long. Now they normally have a few months, like normally it's 3 to 6 months that they need to collect evidence, like in these draconian laws I've mentioned earlier. And then there's also one more draconian law which is not much used in Kashmir but is used in India. Is called National Security Act. So these three of them are actually the detention laws where people are detained. And then but in the Public Safety Act, detained for 2 years, and in the other laws National Security Act for 1 year, and Unlawful Activity Provision Act is 6 months. So people, they can collect information in that time and then they can give it to the prison. But there's been a lot of times that no evidence has been given, especially in Public Safety Act, where the victim, where the person who's been accused, has been in prison for 2 years, and 2 or 3 days before 2 years are reaching, they have been taken out and then put back in again, and they have started the punishment all over again for 2 years. Now, what's happening because of this draconian law? That there's a lot of women who have become half widows. There has been a lot of children who have actually become like half orphan. And the live example at the moment I would like to talk is about Michelle Malik, who is the wife of the Hurriyat leader Yasin Malik. Now she hasn't seen her husband for about 8 years, and her daughter, which is about 10 years old, she hasn't seen her father for nearly eight years as well. Now, which court in this world denies a wife and a child to see their husband and father? But these things are happening in India, and he's been given lifetime imprisonment for laws which don't even apply on him, because he is a person under Geneva Act. He's a protected person, so no law should be actually imposed on him. And under the United Nations Security Council Act 47, till plebiscite doesn't take place, no political prisoners can be detained or arrested. So this is a violation of the international laws and the United Nations Security Council resolutions, Geneva Convention, and India's own actually constitution as well, which says that everybody has equal opportunities under the law. And as I said in Article 14, that everybody's same in front of the eyes of the law. So if other people can go and meet their family members in prison, why can't Yasin Malik's family and the other Hurriyat leaders' family meet them? Now, one thing more, which is very important, which I need to let you know about Article 22. Article 22 has subsection 4 and subsection 7. Now, what happens in the subsection 4 is basically that is to do with the preventive detention in that section, and in section 7 is actually procedures, and it defines the time for the detention and about the advisory council, that like how they are going to deal with the case. Now, these two sections were actually removed, and they were removed when the 44th Indian Amendment Act 1978 was passed. Now, because they have been removed, so what does that mean? That any law which was passed before the 44th Amendment Act 1978 is abolished, is finished, is invalid. So, Public Safety Act, Unlawful Activities Provision Act is actually an invalid law, which has been imposed on Kashmiris and other minorities in India. And what India is doing is completely illegal. So this is not something that India should be doing. And then I'm going to move on because I spoke about Article 20. What is Article 39A? Article 39A is equal justice and free legal aid. And the reason why I'm saying it that our Hurriyat leaders and the people who have been detained, like the Muslim, Sikhs, and other minorities, they are not getting equal justice. Like even the lawyers are afraid to take the cases, because when it comes to Kashmiri leaders, many of the lawyers have been actually murdered, they have been kidnapped, so they are worried about their own safety. So this is a violation of Article 39A, that equality is not being given because people are afraid to actually take on cases. And if they do take on cases, they have been kidnapped or they have been murdered. And then it says free legal aid. Now we don't see that the much free legal aid has been given. And the other thing is like our prisoners are being detained, like they're not allowed to say what they want to say. They have been words have been put into their mouth. Now the last thing which I'm going to touch upon is actually going to be Article 49. Now Article 49 is about the religious places in India. It's about the artistic building, and it's about the historical building. Now what has happened in India? We all know that Babri Masjid was actually abolished, Babri Masjid was actually taken down, and we also hear the other mosque and masjid, like we call it masjid, are actually in danger as well at the moment, because they are turn by turn making sure that they actually demolish our masjids and our mosque, and they are building their own like mandirs on top of it. So this is a violation, because Babri Masjid was like a historical mosque. So it says in this law that anything historical will be taken care of, and it will be treated well, and they will make sure that that thing doesn't have any kind of issues that is broken or has been unattended. But what India is doing is actually violating it.
Do you think the old colonial laws are valid and they are respecting freedom of expression under Indian Constitution, and whether all these laws are within the standards expecting from United Nations and other human rights organizations? How would you analyze this?
Okay, I would go back to Article 19. So what have you said that the colonial laws are not actually respecting the Indian Constitution, and especially Article 19, which is to do with the freedom of expression. And I'm going to talk about two things in like on this part. One is the Afsafa law, Armed Forces Special Powers Act. Now, this law is a draconian law, and this has been imposed. First, it was imposed in seven sister states like Manipur and Nagaland, which is a majority of Christian states. And then it was, for 14 years, it was imposed in Punjab and Haryana from 1983 to 1997, where we hear that the Sikh massacre 1984 incident happened. And then after that, it was imposed in Kashmir from 1990, and it's still there. So this is the biggest example of the like which is a violation of actually Indian constitution and the freedom of expression. Now under this law, even if the Indian army has any kind of suspicion on anybody, they can search, they can arrest, they can torture, they can rape, and they can even kill. And under this law, this law, section 7, which is to do with impunity. So this is Armed Forces Special Powers Act, section 7. Impunity is given that no justification can be required from the army officer who actually carries out this operation, because he is not only an army officer at that time, he's a judge, he's the police, and he's the lawyer at the time. So he can give punishment on the spot, and he doesn't need to give any justification. Now, can you hear in the world ever that even on suspicion somebody has been punished or killed or raped or detained? And this law is called license to kill and rape law as well. So this is the first example I'm actually like passing you on. Now this is a colonial law as well. This was introduced in India in 1942, and this was against the quit India movement the English people were facing at that time, the British Raj, and they actually enacted this law to silence the voices, but they didn't cause so many atrocities as India has been causing since 1957, since it has actually enacted this law in India again. Now, colonial laws. Now, any colonial laws which were passed at the time of British Raj, that was in 1960, are completely illegal and invalid. because India has its own freedom in 1947. So that was Independent Act, Independent Act 1947. So any laws before that have been abolished, and England, like UK itself, has abolished these laws ages ago. Ages means decades ago. So if a law has been abolished by the country which has enacted this law, how can it be valid in India? Now, what India is doing, India has got laws on seduction. Okay, so it is using Indian Penal Code 121 and 124. Now, under these like acts, what it is doing is charging people with seduction. Now, these are laws which were made in 1860, and under this law, if anybody was caught with seduction, first step was to cut their ear. Second step was to chop their neck, like cut the neck off. But by the early 90s, that stopped. And what started happening is that they actually started to give lifetime imprisonment and heavy fines. Now, that law has been completely, in England, the last time they had any seduction law, which was in like UK in England, which was abolished, was in 2009. They start talking, in 1960s, they started to talk that we can't have seduction laws anymore. They are old fashioned, and they are against the human rights. In 1970, a law reform commission said to the government of UK that these laws need to be outdated. So these laws were there, but they were not in use. Then in 1998, England, like UK, passed a law, Human Rights Act 1998. When this law was act, they were decided that we can't have seduction laws because they are a contrary. So they are a contradiction of like human rights and freedom of expression, Article 10, which comes under Human Rights Act 1998. So what the government did is that in a few years' time, by 2009, they made sure that any law with seduction has been abolished. So UK has no seduction law. So if UK doesn't have a seduction law, which actually enacted the law, so how can it be valid in India? So I would say they are not under the standard, as I said earlier, that they are below the United Nations standards, and I will give you examples why. And they're also below the anti-terrorism like laws because they actually was a standard being introduced by the United Nations in 2005. Like what elements actually say that what elements can confirm that somebody is actually involved in anti-terrorism activity. So there were 5 elements at that time. And I will move on by saying that that the United Nations urged to India a few years ago that if it wants to be called a democracy, India needs to abolish Armed Forces Special Powers Act, which is called ASAPA in simple, but India still hasn't abolished that law. And then Amnesty International, which was actually being asked to leave India, their accounts were seized, if you remember, 2 years ago in 2020 after the Muslim genocide, Muslim rights started in Delhi again. So they actually called Public Safety Act, which is imposed in Kashmir, lawless law in 2010. And then we have other laws like National Security Act as well, which are not very active, but they've been used as well. So all of these laws, detention laws, they are below the standard of United Nations and any human rights organization. So I would just say that most of India's domestic laws don't even apply with the Geneva Conventions, international laws, and even they are a contradiction to their own to their own constitution, and it's a violation of the constitution. So any Kashmiri prisoners they have, any Sikh prisoners they have, or any other minorities they have in prison, under the detention laws, they are invalid. They need to be removed as soon as possible. This is against the human rights, and it's a crime against the humanity. Thank you.
Advocate Rehana Ali, thank you so much for your precious thoughts and analysis on and exposing the Indian illegal, invalid laws that are violating Indian Constitution and violating basic human rights in Indian occupied Kashmir and violating your minority rights. Thank you so much again for sharing your thoughts.
Thank you. It's a pleasure to actually become a part of your show whenever you invite me. And I would like to thank you and the audience for actually taking the time out to listen to me and understand the Indian law so we can promote it, we can expose India, and we can make sure that the minorities are safe there, especially the Kashmiris who are waiting for plebiscite from the last 75 years. Thank you.